Good afternoon, everyone. We'd like to get started, so if you could please take your seats. Should be on. Just make sure you talk closely to it. On behalf of the Milwaukee Bar Association, welcome to today's Supreme Court Forum. My name is Aaron Olenichek. I am the president of the Milwaukee Bar Association. The MBA hosts judicial forums as part of its outreach to the greater Milwaukee community and its commitment to having an informed electorate. Thank you for attending today. Not only do we have a live audience here, but we also are broadcasting for those viewing on live stream. We're providing the broadest access possible for this forum while being vigilant about the emerging coronavirus concerns. I wanted to thank the media outlets for being here, and they help contribute to keeping the electorate informed. I want to thank Incumbent Justice Daniel Kelly and Dane County Circuit Court Judge Jill Karofsky, the candidates seeking election to the Wisconsin Supreme Court in our spring election. Thank you for being here today to address your candidacy and to answer our questions. Now let me explain the format for today's forum. Each candidate will be given 2 minutes for opening remarks. The order is based on a coin toss done earlier, and Judge Karofsky will begin with the opening and Justice Kelly will close. You will have the opportunity as part of the audience to submit questions for the candidates. There are cards on the end of the table for you to provide your questions. If you fill those out, raise your hand and a staff member will pick up your card. Your questions must be addressed to both candidates. Your questions can be hard-hitting, but they must be respectful. Questions will be vetted by me for their appropriateness. The moderator will select the questions to be asked. Answers to questions will be given by each candidate. At the conclusion of the forum, each candidate will be given 1 minute for closing remarks, and there will be a timekeeper who will hold up signs when there are 30 seconds and 5 seconds left for a candidate to speak. The moderator will enforce the time limits. And now I'd like to introduce our moderator for today's forum, Steve Walters. For many years, Steve covered state government for the Milwaukee Sentinel and the Milwaukee Journal-Sentinel, and he is the current senior producer at Wisconsin Eye, the state public affairs technological gathering place. We are honored to have Steve with us once again. Please join me in welcoming him.
Thank you very much, President Aaron. Thank you for letting Wisconsin Eye participate. The format's been discussed. Let me provide some introductions. Incumbent Justice Daniel Kelly had a long career in private practice before he was appointed to the court by Governor Scott Walker in 2016. Do I have that right, Your Honor? Okay. And Dane County Judge Jill Karofsky, before elected to the Dane County bench in 2016, right, Your Honor? 17. Thanks. Thank you very much. She was, before that, she was the first woman violence against women prosecutor and the former director of the Wisconsin Office of Crime Victim Services. So thank you all very much. Candidates, thanks so much. And by process of a coin flip, Judge Karofsky, going first?
I am, thank you.
Thank you.
Steve, thanks for agreeing to moderate this. I want to thank the Milwaukee Bar Association, Wisconsin Eye, and all of you who have turned out here today for being here. I would be remiss if I didn't start out today talking about what our nation and our world is going through when it comes to COVID-19. I left my house this morning saying goodbye to a very worried 19-year-old who is home for spring break and will not be going back to finish out her sophomore year at college in Arizona. I left the Dane County Courthouse yesterday having to figure out how to manage a court calendar where we have people who are in custody and we need to attend to their hearings, but we can't be bringing members of the public in to have jury trials right now because we are afraid that it will only spread this virus. We are figuring out what to do in our campaign. We are canceling campaign events. We are doing everything that we can to flatten the curve of the COVID-19 virus. It is impacting many, many of us. People are going to be affected financially. They certainly are going to be affected psychologically. People are going to get sick. We are going to lose people because of this virus. We need to make sure that in this country that we have elected officials who are ready to lead us through times like this, both when we are looking at the administrative branch, we are looking at the legislative branch, and we are looking to our courts. We need to have good, strong leaders who are independent, who will do the right things in a time of crisis. We need an impartial judiciary, especially on the Wisconsin Supreme Court. We're going to get through this. We're all going to get through this because we're going to be able to lean on each other, and we're going to get through it together. Thank you.
Thank you. Justice, your opening statement, sir?
Thank you. Good afternoon. It's great to see all of you here. And it's great to be with you and those who are watching on streaming services. I am Daniel Kelly, and by way of introduction, I've been married for 30 years now. My wife and I, we live in the western part of Waukesha County next to the Kettle Moraine State Forest. We have 5 children. One of them is with us here this afternoon, and they are our treasures. You know, I came to the court in 2016 after a long, deep, and wide practice of law for 25 years. And after that 25 years, I had the highest honor that could be bestowed on me, that appointment to your Supreme Court. It has been the honor of a lifetime to serve you on your courts. Now, 4 years ago, when I was appointed, I started a conversation with the people of Wisconsin about the type of person they want on their Supreme Court. And everywhere I've gone, with whomever I've spoken, I've heard the same 2 things. They want someone who's going to honor the Constitution, apply the law as it's written, without regard to their personal politics or their personal preferences. And then 2, they want someone who recognizes the difference between bosses and servants. And I want to make sure that we understand that the people of Wisconsin are our bosses. We are here to serve them. And so over this past year, as I've been going around the state of Wisconsin introducing myself to all my bosses, one of the things I've encouraged them to do is every time they look at us, every time we put on the robe, I want them to understand they are looking at their servants and that they should be looking to the work that we do and ensuring that we are honoring them by honoring their Constitution. Now, this afternoon, we're going to have a fair amount of time to continue this conversation, and I'm looking forward to talking about our judicial philosophy and the experience that I've brought to the court. Thank you.
Thank you very much. We're going to take turns. I'm going to take turns asking the candidates different questions. Start with Judge Karofsky. Your Honor, why has this race for a nonpartisan office become so one-partisan, so expensive? And finally, is this a template, you think, for all future Supreme Court elections, Your Honor?
Well, I think one of the reasons that it's become so partisan is because you have one candidate in Dan Kelly who is doing things like running his campaign out of the state GOP headquarters. He is standing in front of Donald Trump signs. He has been endorsed by Donald Trump. And so that certainly makes a race for the Supreme Court very, very political. I think that in order to change things, what we need in this state is a really strong recusal rule so that the outside special interest isn't going to have an undue influence in these elections and in the decisions that are being made on the Wisconsin State Supreme Court. We had the opportunity to have a recusal rule, a strong recusal rule, back in 2016. And Justice Kelly and the members of while he was on the court, decided not to even hold a hearing. not to even pull people together to pull the information together that would have led them to draft a recusal rule that would have been clear to the state of Wisconsin. So what we have right now is we've got a for sale sign basically on our state Supreme Court, because not only does Dan Kelly know who he's received money from and who's influencing these decisions, but they know the outside influence know who they have given money to. And I will tell you, as one thing that we are going to do in this campaign is that I am going to recuse myself when I am elected to the Wisconsin Supreme Court on any case where the Democratic Party of Wisconsin is a party to a lawsuit that gets to the Supreme Court. Because we need to make sure that when folks get to the court, that they know that the decision on the court is being made for one reason and one reason only, and that is based on what the law is, and not based on money that has come in during a judicial election.
Your response, sir?
Well, I think one of the reasons that the perception, and it is just a perception, it's not a reality, the reason there's a perception that it's politicized is largely because of what my opponent does when she talks about the role of the courts and what she intends to do if elected to the courts. So this is about our responsibility is to simply apply the law and set aside our personal politics. But I recall the first TV ad that she ran in her campaign. It opened with the statement, "It's getting hard these days to tell the difference between politicians and judges." And then with not more than 5 seconds lapse of time, the narrator went through a list of the policy objectives my opponent wants to pursue if elected to the courts. Well, that's why it sounds politicized, because my opponent is talking about the political matters that she wants to bring into the courts to use to help decide cases. And our responsibility is to reject that. And one of the things that we have a responsibility to reject is this obnoxious and this ugly and this vile accusation that there is a for sale sign on the Supreme Court. You know, my opponent has made the centerpiece of her campaign an ugly slander. The entire rationale for it has been a lie. There's no basis for it. You know, I have 4 years of history on the Supreme Court, and you can look at the work that I've done, and you can see that I decide cases according to the law and nothing else. And this behavior by opponent has been so outside the bounds of appropriate behavior that the majority of Supreme Court justices just yesterday took the unusual step of condemning her behavior in this election. Let me read just a little bit about what they've said. And one of the statements by Rebecca Bradley and Brian Hagedorn said, "Judge Jill Karofsky's irresponsible and insulting statements about the Wisconsin Supreme Court only further reinforce our conviction that Justice Daniel Kelly must be retained on April 7th. Her slanderous statements about Justice Kelly's work in the court are evidence of her lack of fitness for this bench." The statement released by Chief Justice Pat Roggensack and Deputy Chief Justice Annette Ziegler said, "Attacks on the integrity of the court strike at the heart of the judicial system. Such language risks undermining the court's legitimacy with parties, attorneys, and the public. Your campaign has been destructive of the judicial system you say you want to serve."
As moderator, I am not here to censor, so I do want to get Judge Karofsky a chance to respond to that. He was on overtime. You're on.
Thank you. Let me just say a couple of things. Number one, I agree with what the justices on the Supreme Court said yesterday when they talked about the need for us to have a court that has integrity. That is vitally important. But the problem is not this. The problem is not that I am shining a light on the fact that Dan Kelly has an agenda. The problem is that Dan Kelly has an agenda. And by shining a light on the agenda, by shining a light on the corruption that we have on the Supreme Court, by changing that in this election and electing someone who does not have an agenda, that is how we will bring integrity back to the Wisconsin State Supreme Court. Now let me talk about the corruption that we have seen on the State Supreme Court with Dan Kelly on it. Number one, let's just start with a couple of things that happened just yesterday. Dan Kelly yesterday said that he was not promising to recuse himself. He had initially recused himself from the voter purge case. He's now saying that he's going to unrecuse himself, if that's a rule, possibly going forward. This is someone who has stood up in front of Donald Trump signs, someone who has been endorsed by Donald Trump. So, look, he is signaling to Donald Trump he may as well stand up and say, I got your back, buddy. I'm going to be there for you in November. Just keep me on the court. How does that speak to the integrity on the court? It doesn't. That is corruption in its purest form. That is using power to influence a decision to help someone on the court before this case has ever been to the court. It's not even up there yet.
I need to respond to that.
Well, understand, but Justice Kelly, my understanding was you did get off that case, and I'm unclear based on what the judge said. What's your current intent, sir?
Sure. So the reason that I recused myself from that case is because it could potentially affect an election in which I am a candidate. And I believe that it was appropriate under those circumstances to recuse myself from participating in that case so that people of Wisconsin would have the confidence that the justices on the Supreme Court would be deciding it without regard to any outside considerations. And I think it was too much to ask the people of Wisconsin to have that confidence if I were sitting on the case at a time when it could potentially help me in an election. Now, having said that, the oath that we swear when we come to the Supreme Court is to sit on all of the cases unless there is a good reason not to. Now, once the election is over and once it can no longer affect the possibility of my election, the basis for the decision to recuse is gone. And then I say I have the same obligation as all the other members of the Supreme Court, and that is to sit on every case that we can. Now, having said that, that does not mean that I actually will sit on the case. What I have said is that I will look at the case and decide whether there is a basis for me to come back and exercise the responsibility of a Supreme Court justice in that case. Some of the things we'd have to consider would be how much has occurred prior to the petition for review being filed, and whether there are matters that have been decided or winnowed down or narrowed that would impact my ability to exercise my authority as a Supreme Court justice. If that occurs, then I would remain recused. But if there is no reason to recuse, then I would not recuse. And to suggest that I should anyway suggest a misunderstanding of what the nature of the Supreme Court is and the responsibility of a Supreme Court justice, and the suggestion that if I were to exercise the authority of a Supreme Court justice is corrupt is preposterous.
New question. I think it's Justice Kelly's turn. I'm going to ask the same question that I asked then Court of Appeals Judge Brian Hagedorn and Court of Appeals Judge Lisa Neubauer 1 year ago in this room. If you're elected, will you attend rallies, conventions, or other events of either the Republican or Democratic Party? Justice, you're first.
The answer to that is no. One of the reasons that we can attend events at this point is because if you are a candidate for office, the Code of Judicial Conduct provides that you can go and you can meet with anyone in this state. And that's consistent, I think, with the First Amendment, the rights and the responsibility of all of us to participate in civic affairs. And certainly wherever we have an opportunity to spread our messages about how we would conduct ourselves on the court, our judicial philosophies, it is important that we're able to reach out to those folks regardless of the setting. However, once the campaign is done, our responsibility as jurists is to ensure that we are not affected by any outside influences as we decide our cases. And so we want to not only have that be true as a matter of fact, we want it to be true as a matter of appearance, too. And so we don't attend as a regular basis political rallies and political institutions because it lends the impression that you are favoring one side or the other. And so as I have up to this point, I have, prior to the campaign, I have stayed away from those kinds of events and organizations So during the campaign, this is all about meeting with all of my bosses, wherever they might be gathering, even if there's a Trump sign there. This is the idea that we are supposed to avoid, and that it's my responsibility to avoid a certain group of people because they have a sign, is ridiculous. I mean, the whole point of a campaign is for us to take our ideas into every corner of the state, wherever people might be gathered and whatever they might be talking about, to share our understanding of the proper role and function of the court. And I will continue doing that, and I don't care how many signs there might be for anybody.
Judge, would you attend political rallies if elected?
I certainly don't have any plans to do that after the election in April. You know, I think that when we are talking about the corruption on the court, that what Justice Kelly is talking about is exactly why people see corruption on the court. I mean, first of all, his actions speak louder than words, right? This is a guy who stands up in front of a Trump sign, has his office in the GOP headquarters, has been endorsed by Donald Trump, and he is saying that he can stand up in front of as many signs as he wants. That is true, but this is the problem. This is why people in the state don't think they're going to get a fair shake with Dan Kelly on the Supreme Court, because he says, I can stand up in front of as many Trump signs as I want to, but he also is saying, I very well may sit on this voter purge case that is going to very likely involve the presidential election in November. That's why people don't think they're going to get a fair shake. Look, every first-year law student knows that the absolute defense to a claim of slander is the truth. And that is the truth. That is why there is corruption. Let me also just say that, what Dan Kelly does is he says, look, I don't have any political beliefs. I'm not going to tell you what my political beliefs are. But he goes to these rallies, these events where there are Trump signs. He cradles these AR-15s in his arms. He does everything he can to signal to the right, I have an agenda, I'm on your side. And every single time that he has had the opportunity to rule in their favor on the Supreme Court, he does it. So folks in this state don't feel like they're going to get a fair shot when their case gets up to the Wisconsin Supreme Court and he is sitting on their case.
Can I get a chance to respond to that? Yes?
Very quickly, Your Honor.
All right. So all of that you just heard is just the compilation of one lie on top of another. So I've been dealing with this ever since this campaign started, and I've had to debate with her. You know, a campaign, as I found out, is actually a beautiful and a lovely experience for about 98.5% of it. That 1.5%, though, that's a humdinger, and that's this. I have to sit here and listen to her lie and slander not just me, but the entire Supreme Court, and pretend that that's a legitimate thing to do. It's not legitimate. It is a lie, and she has never once pointed to a case.
The Koshky case. The Koshky case.
We'll get to that, that is
the case.
Could he finish, and then you can have a short rebuttal?
So we'll get to that, and we'll look at that case, and we'll use that as a way to describe why you don't understand what precedent is and how you're not prepared to be on this court. But before that, what I got to say is, you have never come out with any evidence that I've done anything improper at all on the court, ever. What you've done is proven that you disagree with the outcomes of cases. And that's a great insight into your mind and how your mind works. You look at the outcome, you compare it to your personal politics, and if it doesn't agree, that's what you call corrupt. And I think you don't understand what the word corrupt means.
An opportunity to respond in 1 minute, since we're trying to get to other questions, please.
Sure, I understand what corruption means, and so do the people of the state of Wisconsin. And when they see you do things on the court, like pluck a case out of the trial court before there was ever an evidentiary hearing like happened in the lame duck case, there wasn't even the opportunity for an evidentiary record, for a trial, so that we would know what the issues are. You were in such a rush to get to the end result, to rule in favor of the right-wing special interest. Your ruling on that case is not going to be a surprise to anybody. That is corruption. What facts could not be developed before that case got to the Supreme Court? The Karofsky case is another example. That case was decided in 2016, and 3 years later, the court ruled with Dan Kelly on it 180 degrees the other way. And the only thing that changed between those 3 years was the makeup of the court, as Justice Ann Walsh Bradley said in her dissent. That was the only thing that changed. How are people in this state to know what the law is when Dan Kelly is not following precedent? It doesn't matter what a court decision is. If he disagrees with it, he changes his mind and he rules in favor of what the right-wing agenda is, over and over and over again.
Steve, I think it's important to respond to those two cases.
Very quickly, sir.
All right. So the Karofsky case, I think this evidence is a misunderstanding of what precedent is. The Karofsky case followed the Coyne case. And this had to do with the development of administrative rules. The Coyne case did not come up with an opinion that the court could agree on. The lead opinion was written by one justice, and it was joined by no one. No one. Now, it takes 4 votes to create a precedent, 4 votes. And no opinion got 4 votes. In fact, the opinion that got the most votes in that case was the dissent. So when we got to Karofsky, what we were dealing with is an inability for the court in the Coyne case to figure out what the law meant. Yes, when I came there, we figured it out. But we weren't overruling any precedent because there was no precedent to overrule because you got to have 4 votes for that. And then on the so-called lame duck case, and this is particularly offensive that you would characterize the parties in the way that you have, because really this does get to characterizing the parties. This is not about right-wing interest groups. This is about 2 contesting parties, both of whom agreed that the case had to be decided immediately, which is why one of the parties asked for an injunction because there was going to be irreparable harm, and the other side asked for a stay on the injunction because there would be irreparable harm if the injunction went into place. Both parties understood that it needed to be decided immediately, and the only question in that case, and this is just your misunderstanding what the case was about, and you need to read it a little more closely, the only issue in that case was a question of law, and the question of law was, did the legislature have the authority to meet and pass laws when it did? You didn't need any factual development in that, and there was nothing that was suggested to us that required factual development. This was purely a question of law, and you have to know, I have to assume you know this, trials are for deciding disputed facts. And because there were no disputed facts, there was no need for a trial. Both parties agreed this needed to be done immediately, and what we did was what a responsible Supreme Court does. There's an aphorism in the law that says justice delayed is justice denied. Sometimes a responsible Supreme Court has to act with dispatch. That's what we did in that case. It wasn't for partisan political reasons. Both the parties agreed that it needed to be decided quickly.
It is 100% false that both of the parties wanted that case yanked from the trial court up to the Supreme Court.
I didn't say that.
That is not true.
I didn't say that.
And I'd like to move on with another question. It's your turn, Judge. Mr. Kelly read the statement issued yesterday by the Chief and Deputy Chief Ziegler. So let me read this question from someone in the audience, please. Our Supreme Court has had a history of personal friction between some of the justices. If elected, what would you do to promote collegiality? Judge.
So I have been a consensus builder my entire career, and I would continue to do that as a member of the Wisconsin Supreme Court. I've already said today that I agree with what the justices said as far as making sure that we have a Supreme Court with integrity. And I would do what I have done throughout my career. When I was at the Department of Justice, I worked with defense attorneys and with prosecutors and with judges and with victims advocates. You never ever see, from 2014 on, see a victim's name in a Court of Appeals decision or a Supreme Court decision in the state of Wisconsin or the briefs filed by the parties, because I worked to get a rule passed in the state Supreme Court. Look, I have been on the front line of our judicial system for almost all of my career, for almost 30 years. This is where I differ greatly from Justice Kelly. I have been a prosecutor. I know how the law impacts real people. I am in a trial court right now. I presided over more than 1,700 cases just last year. I have sat next to victims of crime. I have told their story in court hundreds and hundreds of times. I have made sure that they have gotten the services and the help and the support that they needed when their case was working its way through the criminal justice system. That is the kind of experience that I am going to bring to the Supreme Court. I'm going to bring the fact that I have been on the front line, that I have been a consensus builder. Look, there are going to be areas where I'm going to be able to agree with all my colleagues. There are going to be areas where we have to agree to disagree. But there is that area in the middle where the Venn diagram overlaps in the gray area where we're going to build consensus. And I'm going to use the same skills that I have used my entire career on the front line of the justice system.
Justice, response?
I think your ability to compartmentalize your responses is remarkable. You say that you will be able to work in a collegial fashion with the members of the Supreme Court after you've spent the last year slandering them as being corrupt. There are 2 justices on the Supreme Court that currently say that you are not fit for office because of your slander, because of your irresponsibility, and because of your ugly insults. There are the 2 others who have issued the statements have said that your use of the accusation of corruption is completely irresponsible. It is destructive of the judiciary. And yet you think that you can come to the Supreme Court and act in a collegial fashion? You've spent your last year trying to destroy the character of the people you say that you want to work with. That's not the way that you work collegially with someone. You know, when I came to the courts, there was some concern that I had and others had about the interpersonal relationships. But the approach that I've always taken throughout my career is to walk humbly, to love unconditionally, and to speak the soft word that turns away wrath. And I have found that grace allows people to work collegially together. I have to say that, you know, one of the things that I've really had enjoyed seeing over my career is watching the relationship between Justice Scalia and Ruth Bader Ginsburg on the United States Supreme Court. Jurisprudentially couldn't have been more different, but close friends when outside the court. I have to say that when I came to the Supreme Court in 2016 and not knowing exactly what to expect, I was deeply gratified that the first member of the court who came down to greet me was Justice Shirley Abrahamson. And she came in and she said, "Now, Dan, we are going to disagree a lot. But if you don't twist my arm for a vote, we're going to get along just fine." And she was right. We got along just fine.
Next question to Justice.
Oh, I think I get a chance to respond to that, please, Steve.
Yes, ma'am.
Okay. Look, I'm gonna say this again. I agree with the justices. We need to have a court that is full of integrity, and the problem is not. Look, we need to do everything that we can to uplift the reputation of the judicial system in this case and the Supreme Court. The fundamental problem isn't that I'm saying that there's corruption on the Supreme Court. The fundamental problem is that that Dan Kelly has acted in a way on the Supreme Court that makes people feel like they don't have a fair shake when their case gets up there. And the way we restore that integrity is by changing a member of the Wisconsin State Supreme Court. This is a 10-year term, and it is too important for us to remain silent. Now, all this talk about the slander is just a distraction, and the voters of Wisconsin aren't going to fall for it. They see what has gone on up in that court. They see someone who has found, in the interest of the right-wing special interest, every single opportunity that he has had. He is following an agenda, and the people of the state of Wisconsin don't want that on their court.
A brief response to that.
Very brief, sir.
Yeah. So, might I remind you, Judge Karofsky, that we do have a collegial court, and it requires 4 votes to decide anything. Anything. So when you say that I have acted corruptly because of the decisions that I've participated in, you are saying the rest of the court is corrupt too, because it takes at least 4 people to make a decision. So when the members of the Supreme Court are calling you out on your slander, you don't get to duck that by saying you're just pointing at me, because I work in a collegial court where it takes at least 4. So you are slandering everyone up there.
Next question for Justice Kelly. Justice Kelly, you've been on the court 4 years. Can you tell us the most difficult case you've had to rule on and why it was so hard?
Yeah, I think that's probably the Tetra Tech case. So there, the issue involved there, the ultimate issue was fairly mundane. It was a question of taxation. But there was a precursor question that we had to address, and it dealt with kind of an esoteric issue, one I kind of like. It was interesting. The question was, who gets to decide disputed questions of law? Does the court do that, or does an administrative agency do that? And over a period of a very long stretch of time, over 100 years, the court had gradually developed a doctrine that ended up allowing agencies in the executive branch to authoritatively decide questions of law rather than the courts. And so our responsibility was to go back and look at, have we allowed some of the native authority of the judiciary to escape over to the executive branch? And I ended up writing an exceedingly long opinion, for which I apologize for the length. It was something like 80 pages. But we had a lot of history to cover to get to that point. And I'm pleased that as a court, we recognized that we had allowed some of our authority to go elsewhere, and we decided to recover that and make sure that questions of law are being decided in the correct branch of government.
Judge, you were elected in 2017. Any one case come to mind that was a real tough call?
You know, I have handled thousands of cases as a judge. I heard more than 1,700 cases just last year, which is part of the experience that I'm going to bring to the state Supreme Court. I handled thousands of cases when I was a prosecutor in the Dane County District Attorney's Office. Every single time a crime victim comes into my court and tells his or her story about what happened to them, every time a defendant allocutes at the end of a sentencing hearing and talks about the trauma in his and her life, or the fact that they have had an opioid addiction that they are trying to overcome. Anytime a family member of someone who has been hurt because they were a victim of a crime, or has lost property, or has had something broken or stolen, every single one of those instances is important. And every single one of those instances is really, really difficult. You see the trauma that people endure, and you see the trauma that people overcome every single day when you are sitting in a trial court. And that is part of the experience that I'm going to bring. In my courtroom, I follow the rule of law every single day. And I treat every single person in my courtroom fairly and equally and respectfully. And that is what I am going to do when I am sitting on the Wisconsin State Supreme Court.
The next question goes to Judge Karofsky, and it involves past Supreme Court's terms. Judge, how should the Supreme Court resolve any future ethical complaints against sitting justices?
Look, I think it is really, really important that we have First of all, I think number one, we need to have a strong recusal rule in this state, because what you're talking about is instilling people's confidence in the court. And without a strong and a clear recusal rule, there is just no way that people in the state of Wisconsin have confidence that justices are making decisions based on what the law is. There is absolutely the feeling that without a strong recusal rule, that the decisions are made because of the outside dark money that comes into these races. So we absolutely have to do that. We need to make sure that we have open hearings at the Supreme Court. And since Dan Kelly has been on the court, they've closed the administrative hearings. We need to open those up so people can see how the third branch of government operates. It's your branch. It's your Supreme Court. You ought to see how it is working. So those are two things. The third thing is that we need to have we need to keep having, obviously, elections, and people in the state need to be electing justices who have a track record of following the rule of law, are committed to following the rule of law, and that's what you're going to have in me when I'm on the Supreme Court.
Justice Kelly?
Sure. The system we have right now is we have a judicial commission. They recommend to the Supreme Court. The Supreme Court handles the discipline of judges. I think that's the appropriate way of handling it. We are a separate branch of government. However, the Wisconsin Constitution allows for removal under certain circumstances by the legislature. So I think we have a system that's set up well for it. Let me just answer this discussion of recusal. So this is a continuing concern for all of us on the judiciary, because one of the things we want to do is make sure that not only are we acting in an ethical fashion, but that we are appearing to act in an ethical fashion. We want people in the state of Wisconsin to have the confidence that the decisions that we make are based on nothing but the law and not extraneous circumstances. So we have a recusal rule now, and the responsibility of each member of the court is to decide whether they are incapable of exercising the authority of a justice or would reasonably be considered to be incapable of doing that. And then if that's the case, you recuse. Now, could that be improved? I'm sure it could. No human endeavor, I don't think, has ever come to a point of perfection beyond which it could not be improved. And I think we probably have a fair amount of room for potential improvement. The trick is figuring out how to do that. So we've had proposals come to the court before, and the proposals were really, they were non-starters, partly because they didn't account for both sides of the ledger. The concentration was on what does a justice do if he receives contributions? Can he or can he not sit on a case involving that party? But it didn't consider the other side of the ledger. What happens when a party spends massively against you? Can you sit on a case involving that party? And the problem is that you have to deal with both of those similarly. Gratitude and resentment are equally powerful forces. And until we can develop a rule that adequately addresses both of those, it is possible to do more harm by blundering into something new just because it's new.
Next question is to Justice Kelly. Governor Evers and some lawmakers want an overhaul, a reform of the criminal justice system. The Supreme Court oversees that criminal justice system. Should the Supreme Court, either collectively or individual members, be a part of that dialogue with the legislative branch on how to reform our criminal justice system?
I don't think it should be a dialogue. If they need information from the judicial branch, then I think we need to give that information so that they can make their policy decisions in an informed way. I don't think it should be a dialogue for this very reason. Our responsibility is not to develop policy. That's for the legislature to do. And they do that in the context of conversations amongst themselves with their constituents and obtaining the information they need to make wise decisions. So if they were to ever ask us for input, the information that we would uniquely have that would assist them in developing new policies with respect to the criminal justice system, I'd be very happy to participate in that. But I'm not going to lobby the legislature.
Judge, do you see a separation of powers issue with that, given your experience?
I think that, clearly the legislature is in the position, and it's their job to set policy for the state of Wisconsin. It is not the job of the judiciary to do that. However, as someone who's been on the front lines of the judicial system for most of the last 30 years, let me tell you, if you're in that system for 5 seconds, you can see that it is in need of reform. And so, yeah, I absolutely think that we need to have reforms in the criminal justice system in the state of Wisconsin. We need to do everything we can to try to get more treatment courts. And I see this is something I see day in and day out. Drug treatment courts, we need more of them. Mental health treatment courts, veterans courts, OWI treatment courts. We need more diversion programs like I use all the time, as often as I can in Madison when it comes to community service. Instead of sentencing someone to jail or imposing a fine, we can send them to a community service program. And we need to have more of those throughout the state of Wisconsin. I think that it is incumbent upon those of us who have experience on the front line, which I have and which Dan Kelly does not have, to tell the legislature what we're seeing, what I see every day. How is the law playing out? I think that that's an important thing for them to know, and it's important for me to do that. I just want to circle back to the recusal rule issue. Look, there is nothing stopping Dan Kelly on the Supreme Court from holding a hearing on a recusal rule. He's just chosen not to do it. They've just chosen not to pull all the people together who would have all the information so that they could draft a strong recusal rule. Why? Because he's okay with the outside influence of the dark money coming into these elections. If he weren't, he would have held a hearing, and he would have pushed for reform, and he would have pushed for a strong, clear recusal rule.
Next question to Judge Karofsky. Are you for or against, and this comes from the audience, are you for or against the new business court that Chief Rogenzak just ordered implemented in Dane County? Why?
Look, appearances really, really matter. And the criticism that many of my colleagues in Dane County have about this court, I believe is reasonable. When you set up a system that is two-tiered, and when there is someone from the outside who is telling you which judges are going to sit on these cases, it feels like there are two different judicial systems. One for big business in the state of Wisconsin, and another for everybody else. And that looks like it looks unfair. It looks like the system is rigged. I sit in a court where I hear mostly criminal cases. Every single victim who comes into court wishes that their case had been resolved more quickly. Every single defendant who is waiting in jail to get his or her case resolved wishes that their case would be resolved more quickly. It's not just businesses in this state that need their cases resolved faster. Everyone would like their cases resolved faster. But when you create a system and when you pick who the judges are instead of letting the judges in Dane County decide who the judges are, which is what we do for every other rotation, for our juvenile rotation, for our criminal rotation, for our civil rotation, for our drug court, our OWI court, our veterans court. Those judges self-select. They go through a rigorous training, and their caseloads are reduced because they are doing the extra work of being on those courts. That's not what we're seeing in this court. So it has the feeling for people that there are two tiers, that the system is rigged, and that it's not going to be fair.
Your response, Justice?
I think that's preposterous. We have many different kinds of courts. We have criminal courts, we have civil courts, we have children's courts. We have any number of styles of courts organized around topics to resolve them efficiently. Now, I'm not going to prejudge the efficacy of the business courts, and maybe Judge Karofsky doesn't realize this, but this is a pilot project. We're testing it out. We're gathering information.
Pilot project was over after the first 3 years.
Eventually, we'll decide if this is going to be permanent, and we've not decided that yet. So this is not something that is necessarily going to continue. We have just started implementing these recently. We don't have enough information yet to determine whether this is an effective way of handling business cases. So I'm not going to prejudge that. We'll let the evidence come in, and we'll see what it has to say. But as far as assignment of judges in Dane County is concerned, I'm a little I'm curious about the criticisms on that. This is again, being a pilot, it's being directed from the Supreme Court. And the Dane County is not an independent branch of government in the state. It acts under the auspices of the Supreme Court. And so as we go through the pilot project, it's essential that we have the ability to have that kind of flexibility in determining who's participating in it and in what way. And we'll see what the data is that comes in from it, and we'll decide how that gets resolved.
The next question to Justice Kelly. You were criticized for holding a fundraiser at a firing range 2 days after the tragic Molson Coors incident. And this question from a member of the audience: do you believe people have a right to own semi-automatic weapons?
I believe they have a right to have their rights under the Second Amendment protected. I'm not going to sit here and adjudicate any particular question about how the Second Amendment would apply. In particular, that's the language used in the question. If you could reread that.
Sure. Mm-hmm. Set it aside. Yeah. Here it is. Excuse me. Do you believe people have a right to own semi-automatic weapons, Your Honor?
Right. So that would encompass virtually every firearm manufactured except for a revolver. So it's a fairly broad question. I don't think that there's really been any question that something other than revolvers are acceptable. How far that goes is a question that perhaps would come to the court, and we'll deal with it when it does. But I want to address this criticism of the fundraiser that we held. I was very surprised to hear it, and saddened, frankly, to hear it. I understand that in political campaigns that the tendency is to take cheap political shots. I get that. But the criticism at the base of that is an assumption that describes a level of moral bankruptcy that is just appalling. And because that's so appalling, I refuse to believe that those who criticized the fundraiser that we had, I refuse to believe that they actually thought it through. I think they just did it for the cheap political hits. And, like I said, in a campaign like that, this is one of the things you got to live with. But at the base, if you were to actually think through that criticism, here's where the moral bankruptcy comes in. That criticism only works if you equate that sick, twisted individual who killed his colleagues with the people that I was with at the Wisconsin Firearm Training Center. Now, the folks I was with, they were just doing what they could to get the training and the tools necessary to protect themselves, their families, and the innocent people around them. And there's just no way in the world that you can compare them with that sick, twisted individual.
Judge, your response?
I had the opportunity a couple nights after the tragedy here in Milwaukee to speak with some of the people who worked with the victims of that tragedy. They were heartbroken. They, I'm sure, continue to be heartbroken. As someone who has worked with many, many victims of crime, it takes time for people to heal. They heal by coming together. They heal by sharing their stories. They heal by knowing that they're going to heal at different paces and different times, and they're going to have different triggers along the way. This gun rally for Dan Kelly's campaign was a way to inject politics and partisan into this race. He has, and his allies have been ginning people up all over the state of Wisconsin. They've been spamming my email and my Twitter account and my Facebook account and our phone lines, saying that we are gonna, by some magic force, come and yank every gun out of every hand in the state of Wisconsin. I believe in the Second Amendment. I believe in what Justice Antonin Scalia wrote in the Heller decision, which is that the right secured by the Second Amendment, like most rights, is not unlimited. But I respect the Heller decision, just like I respect all precedent in this state. I'm not trying to do whatever it is that Dan Kelly and his allies say that we're trying to do. But look, there's a photograph of Dan Kelly cradling an AR-15. He stands in front of these massive Trump signs. You know, he's saying that the attacks on his campaign and his credibility are unfair. Too bad. Too bad. This guy is running one of the most partisan political campaigns we have ever seen for Supreme Court in the state of Wisconsin. He is he is an unwavering vote for the right-wing special interest in this state. He doesn't care about fairness or precedent or the rule of law. He cares about fulfilling a right-wing agenda. And in this election, we have a chance to make a change.
30 seconds, sir.
So, of course, none of that is true either. I'm not running a partisan campaign, and everyone who comes to any of my events knows that full well. So the campaign that I'm running is one of constitutional fidelity and faithfulness to the text of the laws that we apply. And I take that message everywhere I can, without regard to politics, without regard to who they are when they vote in partisan elections. I talk to everyone who will listen to me. And I bring the same message to every single one of them. It's the exact same message. And it's the one about being faithful to the Constitution. It's about keeping the politics out. And you know, one of the most gratifying responses I've gotten from the appearances that I've done all over the state is when someone comes up to me, and this has happened more than once. They come up to me and they say, "You know what? That is the most non-political stump speech I've ever heard." And that's because the stump speech has grown out of the work that I do and my love of the law and the fidelity to the Constitution that is required. It is an organic outgrowth of that. And so when I appear in front of folks, if this is about partisanship, I am doing the worst job ever as a campaigner because I never tell anyone that I'm going to follow their politics. And in fact, regardless of who I'm standing in front of, I tell them explicitly, I'm not going to follow your politics. I'm going to follow the law. You take care of your politics in the legislature. That comes over to the court. We'll apply that. But if you're looking for somebody who's going to carry water for you on the court, it's not me.
And I've been told this is the last question before closing remarks for time constraints, and it goes to Judge Jill. The Capital Times recently reported that the number of bail jumping charges has absolutely soared to 15,500 in 2016. Because of this, former appeals court judge Paul Higginbotham has said the Supreme Court should consider bail conditions. Where are you on that?
Again, as someone who has been on the front line of the criminal justice system and deals with bail hearings very, very often in the course of, if I don't have a bail hearing many, many times a day, it's because I'm in jury trial and I just am not able to fit it on my calendar. But I think that we need to look at bail reform in the state of Wisconsin. Again, I'm not running to reform the system, but I'm happy to tell the legislature what I see. And there are many, many studies that talk about the need for bail reform and the impact that bail has. You know, if you hold someone just overnight, that has an incredible effect, just one night has an incredible effect on their livelihood, has an incredible effect on their ability to work, their family, them getting to school. But you also always need to balance it with making sure that victims in the community are safe. So it is very, very complicated, and those are issues that I have worked with and faced my entire career. I would be happy to inform the legislature as to what I have seen regarding bail, what I have seen works, what I don't think works, and that is what I would be happy to do that. Just in response to a couple of things that Mr. Kelly said, you know, it's not that, you know, he can stand there, he can sit here and he can say, look, I'm not saying that I'm not a Republican. The Republicans know he's a Republican. They know where he's coming from. They know that when he was appointed to the bench by Scott Walker, he was appointed for one reason only. He had no judicial experience when he was appointed to the Wisconsin Supreme Court. But Scott Walker wanted someone who would carry the water of the right-wing special interests and of corporations in the state, and that is exactly what Dan Kelly has done every single opportunity he has had while on the court. And that is what he is going to continue to do for 10 more years unless we make a change on April 7th.
Mrs. Kelly, the issue is, do we need to look at bail reform, sir?
Sure. I think that's an entirely legitimate subject for the legislature to address. And again, as I've mentioned before, this is not really a dialogue. We're not there to lobby the legislature on what the reform ought to be. But I think that to the extent the legislature could use information that we uniquely have, I'd be happy to talk with them about that. As far as the rest of this, so this would come to news as news to Scott Walker. It comes as news to me that he appointed me to carry water for him. That's not what he told me, and it's not what he told the people of Wisconsin. And so now you're just adding more lies to your prior lies. So now you're lying about Scott Walker, too. Now, he's a big boy, and he can take care of that. But I never heard that from him. I never heard any suggestion of that from him. The process that I went through to be appointed to the Wisconsin Supreme Court, and by the way, I've been on the Supreme Court longer than you've been a judge. And when I went through that process of being appointed to the Supreme Court, I never once heard anything in that months-long, intense process. I never heard once anything about politics. Never once. The people on that commission were looking at judicial philosophy. What is your view of the law? Where does the authority come from? How will you use that on the Supreme Court? That is literally all they talked about. We had treatises and cases that went through various kinds of judicial philosophies and quizzing me on where I stood on those matters. And that's what brought me eventually to the governor's office. And when I stood in front of the governor, he asked if I would faithfully apply the laws. He didn't ask me about my politics. We had no discussion about politics. He asked me if I would faithfully apply the Constitution. Would I be faithful to the people of Wisconsin? And would I do my utmost to make every effort to decide every case according to the law? And I promised I would. And after I promised I would, I took an oath to that effect. And I have maintained that oath these last 4 years, and it has been an honor and a privilege to do so.
This ends the question and answer period. I want to thank you for your questions. We're now into closing statements. And by coin flip, Justice Kelly, you're going first, please.
Thank you. Well, actually, this is just a continuation of my last answer. It has been an honor and a privilege to serve the people of Wisconsin on their Supreme Court. I learned a long time ago that the role of a Supreme Court justice is essentially a humble one. We are not there to tell the people what their Constitution is. We are not to tell them what their laws are to be. In fact, the relationship goes exactly the opposite, and it has been a privilege over this past year to go around this beautiful state and remind people of who they are as we, the people, and how they have all of the authority to create and maintain governments, and that as they created their Constitution, they have said in that document what we are to do, and it is a command to us what we are to do. And they've told me that we are to exercise the judicial power, and that is just taking the law that already exists, applying it to the case in front of us, and coming to our judgment. And specifically, that's leaving everything else to the legislature to decide on policy matters. And so as I have, over the past 4 years, as I've had the privilege to serve these wonderful folks here in Wisconsin in this capacity, I have fulfilled that. I fulfilled that promise and that oath. And so now, as I go through the election process, this is a process of putting myself in front of my bosses and asking for their judgment on me, and asking them that if they find me to be a faithful servant to them on their courts, that I faithfully applied the Constitution and their laws, that they would grant me permission to continue serving them for 10 more years. And I asked them for that permission, and I'm grateful for it.
Closing statement, Judge Karofsky, please.
First, I'd like to thank you, Steve, for moderating. And again, I'd like to thank the Milwaukee Bar Association and those of you who showed up today. Thank you for being here. When my opponent talks about his 6 million bosses and being their servant and listening to them, that's just not happening. He's not listening to his bosses. He's listening to the Wisconsin Institute of Law and Liberty. He's listening to Scott Walker. He's listening to the right-wing special interests. It is time that we put a stop to this on the Wisconsin State Supreme Court. What I'm going to bring to this court is my experience of being a trial court judge, of hearing thousands of cases, of seeing how the law impacts real people in our state. My experience of being a prosecutor, of knowing how to protect individual rights and the importance of protecting those rights, of being a victim advocate, of helping people in every single county in the state of Wisconsin get the rights and the services and the help that they needed. That's what I'm going to bring to the Supreme Court, in addition to my Wisconsin values, in addition to my toughness and my independence. And I hope I can earn your vote on April 7th. This is an incredibly important race for the people of the state of Wisconsin. Thank you.
On behalf of Wisconsin I want to thank you for letting us participate, and I think President Aaron is going to close and help us thank the candidates.
Thank you, Steve. I would like to thank Steve Walters for moderating this forum for us. Thank you, Steve. I would also like to thank the candidates for participating. Justice Kelly, thank you. Judge Karofsky, thank you very much.
You're welcome.
And I would like to thank all of you in attendance for being here and participating today. Thank you all on Wisconsin Eye and on closed circuit for watching and attending. Your interest in this race is important. Please remember to vote in the spring election. It's April 7th. It's coming up fast. Special reminder to MBA members who are here and who are watching, the MBA is now conducting its annual judicial poll. Members should have received ballots by email, so check your email. Please complete yours by the deadline of March 20th. There will be a circuit court judicial forum right here this coming Monday, March 16th. This forum is for Milwaukee County Circuit Court branches 5 and 29. Candidates for branch 5 are incumbent Judge Paul Dudinsky and challenger attorney Brett Blummy. For branch 29, incumbent Judge Dan Gabler and challenger attorney Rebecca Kiefer. Finally, another reminder to vote in the spring election, April 7th, and remind your relatives and your friends to vote. Thank you all very much.
And just a PS, this forum will be available on demand, wisi.org. Thank you all very much.
Great, thank you, Steve. Very good, excellent work.
Thank you, sir. I really appreciate it. Yeah, there we go. Thanks for hosting.
You bet. It's very important. We want to get